So, welcome to everybody on our webinar today. Are you keeping personal data longer than you needed it? Bristow's are hosting this for the Data Protection Network, and as you can see, in addition to myself, Robert Bond, I'm joined by Nina, Simon, Matthew and Claire, whom I will briefly introduce in a moment. Over the next hour, we are going to talk through essentially data retention. And the driver for this particular webinar is that the Data Protection Network has been beavering away over the last 6 months to try and come up with guidance on how to effectively create a data retention policy, given that there's not enough, in our view, practical guidance out there for all sorts of sectors. And so the speakers today represent different parts of industry. And we hoped that for those of you on the webinar today, if you're not already involved, we would love to hear more from you because we're looking for case studies and so on. The Information Commissioner's Office is aware that we are doing this piece of work, and so we're hoping that next year we will have our first version to make public. But as we go through today, we may well reference where we are at with certain parts of the work in progress. This webinar will be recorded and will be available for download in a few days' time. There is a question box, as you know, so do send in questions, although most of you, when you registered, raised some really good questions which we've distilled down and which we will talk through, seek to answer and so on as we go through the session today. So, I think most of you know me. I've hosted a number of these webinars for the Data Protection Network in the past, and there is my bio on this slide. More interestingly, I wanted to introduce Nina Barakzai, who is the Chief Privacy Officer and General Counsel Data Protection for Unilever. Nina is also President and Chair of the In-House Council Worldwide, and past chair of the UK's Commerce and Industry Group representing UK In-House Council, and brings the business to consumer and business to business approach in terms of data retention. So lots of expertise from Nina, which we will be drawing on as we go through. And then Simon Blanchard, who is the Deputy Chair of the Data Protection Network, is a Senior Associate with Opt4, and having been in-house, is now providing consultancy on a range of compliance issues, policies and procedures, including data retention, and has been very instrumental in driving the DPN work on the data retention guidance. Matthew Kay is the Data Protection Officer EMEA at Thomson Reuters. Matthew, of course, was at the ICO a number of years ago, and as you can see, has held a number of in-house positions since then, and brings a wealth of experience both from within the regulator, but also within industry to, again, issues around data retention. And then finally, Claire Robson, who's the Head of Legal and Compliance and DPO at Great Ormond Street Hospital Children's Charity, brings a different side of data retention. Obviously has past experience within NHS medical record type issues, but now there are specific issues around the role of GOSH and charitable data, users data, where it helps to flesh out the challenges that we face. And obviously, where there is a legal and regulatory issue, my colleagues have already told me that they're going to be staring across the table at me, and I am going to be the fall guy for those detailed legal questions, being the lawyer in private practice. So before I hand over to Simon in a minute, I just wanted to remind us, and this I have literally cut and pasted from the ICO's website, on what is meant by storage limitation. I'm not going to read this, but the italics is what the law says in GDPR and so on, and then the guidance from the ICO is the above means you must not keep personal data for longer than you need it. You need to think about and be able to justify how long you keep personal data. This will depend on your purposes for holding the data. You need a policy. You need to periodically review what you hold, delete that which you do not need, consider any challenges to your retention of data and the balance between what you have to keep versus what individuals believe you have to erase. And you can keep personal data for longer if you are only keeping it for public interest, archiving, scientific, historical research or statistical purposes. That's not entirely true because, for example, as a notary public, the law requires me to keep public documents forever. That's the document, but of course it will include personal data. What's interesting about these ticks that we've got here is it still uses generic language like no longer than is necessary. You need to justify what you're doing. And that's really why we are sitting here, because we want certainty. All the questions we've had in from you are asking for definitive answers. We may disappoint you and not be able to do that, but this slide sets up the challenge. And then the next slide, again, drawn from the ICO's guidance, when we ask the question, how should we set retention periods, says GDPR does not dictate how long you should keep personal data. It's up to you to justify it. You are in the best position to judge, and that's why it's not one template for all. This will be dependent upon the quality of the data, sensitivity of the data, and your business. You also must be able to justify what you need to keep in a form that permits identification of individuals. If you don't need to have personal data, then anonymize it, aggregate it, etc. These are a couple of, again, the throwaway comments from the ICO, which are okay, but still leave us all looking at the ceiling and wondering what the actual answer is. So the focus of today's webinar is where to start, how to make decisions on retention periods and overcoming the challenges of implementation. And this is where I hand over to Simon and sidestep the really tricky stuff. Simon.
Thank you very much, Robert. Hi, good afternoon, everybody. So I'm going to look at kind of where we get started on this. So as a first step, I'd suggest that organisations need to kind of first fully understand what personal data is it that they've actually got, what are they processing, and also think about the provenance of that, where's it come from. But just as importantly as understanding what personal data you have across the organisation, be thinking about what are the specific purposes that you're processing that data for, which might be multiple, of course, for any particular data set. So that raises kind of the first question on that is, do you have all that information to hand, first of all? And for many organisations, that may be, well, some of it, but maybe not all of it. You might be in a position, for example, where you might be in a very fortunate position where you've already mapped all of the data flows that you have across the business. And you may have obviously logged all of that information into your records of processing, which would be a good position to be in. You may alternatively be kind of trying to start from scratch and be an organisation that's then trying to build up that picture of all of the processing that you have across all the various functions. Probably more likely for many organisations, they're somewhere in between. They know about a large proportion of the processing, but they still need to kind of to improve that more to get a complete understanding of all of the data. So that, I think, would be the first bit. And in terms of how you might go about that, if you're looking to get in a better position for that, what are your options really? So the first one might be to trawl the existing information sources that you have, so your IT systems, your compliance records and your legal records, etc. Any data mapping that you've done in the past, the contracts that you have with third-party suppliers, things like that, they will all give you some understanding and some insight as to what data you're processing. Alternatively, or in addition, perhaps you might use some data discovery software. to be able to trawl across all of the systems that you have for personal data. Be mindful, of course, that if you go down that route, you'll still need to be able to interpret what the outputs of those are. You may get quite a technical output and then have to turn that into a form that you can understand and interpret and use in the way that you can for the purposes of then being able to identify first your lawful basis, but then moving on to, so how long should we be retaining that data? Another approach could be, that's quite a common one, is to then engage with the rest of the business and to start to talk to all of the functions that process the personal data, those that are at the sharp end of the processing. And we often find that it helps to run a kind of a discovery workshop where you can go and talk to kind of the key functions and the people in those functions, and to engage with them, not just about data protection, but helping to understand around the processing that they're doing, and to look at the different purposes that they're using that data for, and then to start to shape out what's the retention periods look like based on the different periods. You should remember, of course, that the data, your data footprint, let's call it, will keep evolving over time. Nothing stands still. Organisations are changing all of the time. So an activity that you do to understand your data kind of architecture, let's say, or your mapping at any point will have changed probably quite a bit over the next few months. So keep updating it. So that would say is the first step one. The next step, I would say, to think about categorising that data in a way that really works for your organisation. And I think there's a few different approaches that you could take. So let me give you a few examples. So for example, you could choose to categorise your data by the kind of type of data subject. So for example, your employees, your customers, your prospects, your business clients, etc. It might be that, I'll give you an example, if you're in healthcare, for example, you might also have patient special category data, medical data, things like that. If you're a charity, you might also have donor data, legacies, families that you support, maybe. So each of those would maybe require a slightly different approach. So maybe working by the data subject type might be a good way for you to categorize your data and therefore make decisions about how you would apply retention to those different categories. The second option is to do it by function, which might have some similarities. So maybe you would look at it by function, as in your HR department, your marketing, operations, finance, procurement, etc. That's another perfectly valid approach that works for many organizations. And another one that I've seen used is doing it either by, say, country or by region, where different local laws may apply. Particularly important if you have multinational or European or global sort of businesses. And thinking about it from both from where you operate as an organisation, but also where is it that your customers and the organisations that you trade with, whereabouts are they based as well? Because different laws may apply. So if, for example, you've got processing operations or customers in the UK and Germany, Spain, etc., and other parts outside the EU, you'll need to think about the regulations that apply in those different territories. So that will be the second bit, thinking about how you categorise the data. And just really also, before we go on to the next section, I'd like to just mention some of the considerations that I would say that probably be good to be mindful of before you get started really on the work. The first one I think I've probably already touched on is to think about where you're processing personal data for multiple purposes. And that obviously is going to complicate things. If you're processing a certain data set only for one purpose, it's relatively straightforward, hopefully, to be able to set a retention period against that. But you should be mindful that if you're processing a data set for multiple purposes, you may keep some of the data for a short period and other data for a longer period, and that takes a bit of working out. Secondly, think about things like if you have a lot of unstructured data, perhaps, or maybe you process images or other types of data that might be harder to wrap your arms around. Be thinking about things like that as well. Don't forget your physical data that might be stored on paper files, in archive boxes. That equally comes within the whole breadth of GDPR and the regulations as well, and also from the point of view, you should be thinking of from the basis of your data subjects and your responsibilities to them as well. So think about that. Who knows, some people might still have microfiches as well. Things like that, perhaps. Then I'd say thinking about some kind of external factors. So are there, for example, in your sector or where you work, are there any kind of inquiries or investigations affecting that sector that might require you to hold the data for a longer period? I mean, PPI might be a good example of that, for example, that we're familiar with. Things like that. And also then finally, I would say just think about how you would go about engaging people across the organisation, because at the end of the day, you've got many people across most organisations that are actually involved in processing the data. They'll be able to give you a much better understanding of the ways that they process and how they process it and why they need to retain it for certain reasons. So be thinking about how you go about engaging those people, and just encourage coaches try and speak their language as well, and to think about it in terms of real examples for the different functions that you work with. So I hope that kind of sets the scene for how I'd probably think about going about making a start on it.
Yeah, and actually, as you've been talking, Simon, one or two questions coming in live. So I'm just going to ask you, in your experience, are you finding now that there are suitable tools or technology out there to help you to manage and update records that way?
Yeah, thanks. I think those tools are improving all of the time, to be quite honest. There's a variety, there's a huge number of tools out there that you can use. But I think, yes, they are improving all the time. I think part of the challenge is to be able to get across the whole of your data asset. And I've seen instances where certain tools will give you a large proportion, but maybe not cover everything. So that can be a challenge. I'd say the key thing is making sure that a tool that you use will be able to cover the whole of the assets that you use. And then secondly, look at how it actually interprets that information so that you can make some reasonable decisions from it, and not just have a massive great list of data that comes out at the end of it, but it's something you can really use. But yeah, that's a perfectly valid option.
And then, not necessarily for Simon, but just if anybody wants to chip in, obviously what Simon was describing was, how do you get into the detail of what goes in the schedules, whether it's on a country basis or on a category of data basis? But to what extent, say, Nina, do you find that you set a scene with the policy and then drive the detail into schedules? Is that how you tend to do that?
I think it's a combination. So in any business, as Simon said, you will be facing quite a lot of commercial and financial and data change. So something you might have collected a year, 2 years ago would have been completely relevant and useful then. Now, because your business has grown, developed, expanded, contracted, that same data may be just as necessary, but for completely different reasons and for completely different uses, but it may be the same core data. So for any of us dealing in the personal data space, it's normally name, email address, telephone number, contact details of some sort, and perhaps an IP address or gender and age because it's specific for the service. I think in those situations where you're talking about how to do things, whether you can do them through policy or whether you can do them through a particular schedule, at every stage you might have set one particular approach with the business in mind at that time, but you must be able to flex. So this is in a sense a function of our world now. Everything can be online but doesn't need to be. And Simon talked about types of data, categories of use. I think we're looking at data retention. So I will always think of what the risk is and what happens if I don't do something, what happens if I do something. And if I'm thinking about data and retaining it, then if there is a way to retain it through categorization that minimizes my risk, then I will of course drive a policy that will help me there. So your question was, can I drive it through policy or schedules? I would like to assess on both fronts, because I think for any business, any commercial team, they're not really looking at the law, they're looking at how to make their business run more effectively. And so you do need to be able to do both. A policy being set up front is helpful, but it must be able to flex to run with the business without getting them into trouble. So one of my Latin American commercial managers a couple of weeks ago said, I really want to do the right thing, but I need you to set the guardrails. So set them so that we can be as safe and honest as we would like to be, but within some level of flexibility. And I think that's where data retention comes into its own, because you can do both if you work at it.
Okay, and Claire, thoughts from your side of things?
Yes, I think I agree very much. What we've tried to do is set the policy which gives a broad view of where we want to be, and then we'll use schedules and things more specific to us as an organisation in order to implement that policy. So particularly around retention, I've always advocated setting minimum periods of time rather than maximum, which gives you some flexibility and scalability around how long you're keeping information for. But it's also really relevant to look at the organisation itself. So your size, your structure, the amount of records you hold will very much depend on what you want to keep and how you want to keep it and how long you want to keep it for. And that also enables you to let your policy move with you as a business, so that as you grow or shrink, your policy can adjust with that as well. I think the other thing it's always really interesting to think about is it's very easy to overthink this and make it really complex. And to a degree, particularly if you're starting from scratch, simplicity is the key. You have to be able to implement whatever you document. And if you start getting too complicated around your retention periods or your record categorization, you will struggle to implement. And you need to make sure that technically you have the capability to do it as well. So can your systems delete information? How easy is it to delete? So these are all things to consider when writing that policy, which will inform your schedules.
I think the other thing to bear in mind, because I think you've triggered some really good thoughts in my head, the GDPR asks us to explain. And so all of those things you've described about being clear and simple and easy to understand need to be able to be explained to somebody else.
Yes, very much so.
Yeah. And that's, so we're going to come on to what's necessary and so on, but the word that, you know, was right at the beginning from the ICO was justify. So you can't be glib and say we keep it as long as is necessary, full stop. You've actually got to be more detailed. But one of the other questions we've had whilst we've been talking, which in a way you've already started to answer, is, you know, what's the level of granularity? How detailed should we be? And the answer is the more detailed you are, the more of a problem you're creating for yourself, but the more glib you are with respect, the more problem you're creating as well. I mean, you know, I'm looking at Matthew here, who's been in the construction sector, now moved into a different, I mean, what have you seen out there in terms of the way that the policies have been laid out in general?
I mean, I think in terms of how granular you go, it's going to be heavily dictated by organisational resource and size, and how much priority they want to give to this area, because the better you can manage your records and the more clearly defined it is in terms of your data flows and where that information is going, how it's being processed, the better your organisation can function in this area. So ultimately, if you leave things to chance, it increases your risk from a regulatory point of view. So how granular you go is going to be dictated heavily not just by resource, but also by what information the organisation is processing, because some organisations will process broader categories of data, high risk data, than other organisations will. So in terms of in the tech space now, to where I worked, to where I previously was in construction, to local government, it's totally different challenges. Whilst there's some similarities in terms of every organisation has financial records, HR records, you look into local government health, they have distinct challenges in terms of healthcare records that bring with it their own unique risks. So I think ultimately that is a judgment call from the organisation to ultimately make, but whatever is left to chance puts at the risk in terms of potential enforcement action if we see information has been left for longer than it should have been. If it's not accounted for, then potentially it can be mishandled, misused, etc.
Okay, and we are going to come on to, and again, one of the other questions we've had is around the enforcement issues. And we've got several of those questions which we'll look at a bit later on. But if we can move on, one of the other things that we're trying to answer in the guide is, well, how do we decide on what is the appropriate retention period? And we've been asked, well, are there legal and statutory requirements? And that's what we should be sitting down and asking ourselves. And that will depend completely on your sector, because there may be, like I said at the start of the webinar, if you happen to be a notary public, or you happen to be a government agency that is driven by a requirement to store and archive, then you may be keeping things for, if not forever, certainly a considerable length of time. And actually what you're keeping is more the document than it is the personal data, but of course they are intertwined. And again, if you're in clinical research or you're a medical device organization, you've got medical regulatory rules that will dictate what happens. And the same will apply for almost every sector that you think of, for all of those of us that are sitting around the table. So the starting point is we need to know what those particular legal or statutory or regulatory requirements are. And as Matthew said, you could have in almost any organization similar categories of data. So there'll always be corporate information, and there will be a requirement to keep corporate records. There will be a requirement to keep records to defend your position. I think we talked about PPI claims and so on. That's where the big mapping for your schedules needs to come about. And that means that if you're the compliance person or you're responsible for this, you cannot work alone. You're going to have to interface with treasury, with finance, with marketing, with sales, with regulatory officers, etc. So it's quite a big job if you're going to do it properly. And I think we'd probably all agree it's not a one-time document either. It's a living and breathing process. But there will be, for let's say HR records, statutory requirements about how long you would generally keep a record during the course of employment and thereafter. And we often see periods in what we're working on now where it's 6 years or it's 7 years. But then you ask yourself, what do we do with a job applicant when we don't give them a job? What's a reasonable period then? What is necessary? And that's the other bit where I think, again, in terms of transparency and honesty, you've got to be able to put in here something that describes how have you reached your decision that this is fair and reasonable. Because you might say in one industry, it's not unreasonable to keep a job applicant's data for 6 months. In another, you might say because of the niche area, it could be 2 years. And we might be using that to re-invite them to apply again. So again, it's very industry specific. And I'm intrigued from the rest of you, what are you finding is the how do you justify necessary? Leah?
I was looking at Simon while you said that. I think my first reaction would be, what do I need it for? So I am used to working with personal data for quite some time now. Invariably, I have requests from people who say, I need to retain this data set because somebody is leaving and we need to have access to their information because there's a commercial business need. And I think that's fine because you can normally justify. But the one thing that I have tended to ask when I get those questions on a repeated basis is, this has been extended. How many times in the past X period have you accessed those retained records? And I think that can apply whether you've had an extension request or not. The most critical factor is, yes, that you will need to have certain data for your business activities. No issues at all. The legislation allows you to do that. But when there is this request to keep data for an extended period of time, I think it is important to say, yes, we need it, but if you've got data for longer than, for example, 2 or 3 years when everybody else needs it for 3 months, the first question is, why do you need it? But the second thing is, okay, you've had an extension already. In that extension period, how many times did you access that retained data? Now, I can understand for things like insurance policies, which might be annual, for activities and recruitment, which might be 6 months or 2 years, as you described, that's fine. You can probably demonstrate how many times you need to access the data. But if there is data that is just sitting there, it's a cost to the business to hold it, because you have to make sure the systems still work and the old software can be upgraded so you can still access that data. But from a privacy perspective, which is my focus, I have a higher risk the more data I keep. If I'm not using the data for trends, if I haven't depersonalized it, is there a way that I can say, I've never accessed that 3 years worth of data, and therefore I can't demonstrate that I really do need to extend retention? Now, Simon and I, before this session, were talking about tagging of the data. I think when you ingest and take in your data, you'll have a purpose, you'll know what it is. If you're changing it, as we described, when the business changes, you may have a secondary purpose, which Claire was talking about, and Matthew was talking about. You may tag it on a second time, and then at the point when you get asked about the data retention, you can look at those tags and say, do they still apply? Do I still need this data? Do I need to change it? But at that stage, you have a history, you can see what you've been doing, and you can then tell yourself, okay, I really do need this data, but maybe I can shrink it. Maybe I can adjust it. And there you come to your data deletion, your erasure, and all of those other associated points which the legislation requires us. But commercially, you may still have your data that you need, but it may have been de-risked slightly. So to answer the question, is there a legal or statutory requirement? Yes, absolutely. But what's necessary? I think you have to make those decisions yourself on the basis of your business. But there are so many things that you can do to take it out of the risk category. And I think that's really where you start, is where do you de-risk this? Because you may still need the data. And how do you de-risk it? And that's when you might pick up some of the things, Simon, you and I were talking about earlier on.
No, I think you're right. I think that as an approach, I think that really makes a lot of sense to me in terms of how to tackle that. Maybe in terms of the other things, maybe to think about in terms of what is necessary. If we take it from that point of view, what constitutes the word necessary, as we've got here on the slide as well. Thinking about things like industry standards and guidelines maybe as well, and what's commonly held good practice, because in many industries there already is existing good practice that you might need to also consider. The other thing that we talked about, Nina, was also things like the product life cycle and things like that, which I think you touched on actually already, to be fair. But in some sectors there's a product life cycle that's relatively short, and in others, for example, I met a gentleman that worked in the memorabilia market, where actually you could argue that the retention period on something like that was very long. So that there are situations whereby you can justify a longer period by considering what's the appropriate life cycle for that. And thinking also about is there a potential for litigation as well? If you keep it for too long, or in fact if you don't keep it for long enough, of course, we've already touched on as well, there's equally that risk. So there's quite a few other considerations, I think, in that area.
And in fact, one of the questions I didn't even get to ask you was, can you give examples of the sort of risks you would consider? So to the person who sent that in, I think we've already answered that. And again, I think Nina touched on a key consideration is the interface between retention and then all those other policies like deletion, and how do you manage data subject rights like erasure and so on. And I think any of us who have had a difficult situation with an individual would probably ask ourselves, why on earth did we keep that data? If we hadn't had the data, we wouldn't be facing. So
I think I'd take issue with that. So, as a data protection officer, I think the role of the legislation helps both the companies, the controllers, and the data subjects. I think if you have the data, that you will have collected it for a legitimate purpose, and if somebody asks for the data, then you release it in a legitimate and appropriate way. I don't think that the legislation is there to keep you kind of from falling into a sticky mess if you've caused yourself a sticky mess. But I do think that there is, and I think this is perhaps a very good point to think about, the law is there to protect both sides. It is an equal and fair approach. We may not all be completely happy with having to do certain things because they take a lot of effort, but I don't think that wouldn't be the reason why I would say, oh, I wish I hadn't had the data. I think you have to be able to say, and I know you're being a little bit humorous there, but I do think we need to be careful on the call. We need to give people a clear view of what's practical and what's doable. It doesn't mean that it's a get out of jail card, but it absolutely does mean you have to be responsible and accountable. And I know that's a very easy phrase to say, it requires hard work, but if you start it with that perspective in mind, from both the controller and the data subject's perspective, it's a much easier task then to move forward through all of the things that Simon and Claire have been talking about, and Matthew. I think, you know, we need to be really conscious that this is equal on all sides.
Yes, and I guess actually being more serious, if you have got a sensible policy, at least when things, because they will go wrong, you would still be in a better position to look the regulator in the face and say, here is the approach which we took, and they may not agree, but at least you can show you were moving in the right direction, this was not done lightly, etc. If we move to the next slide, we've distilled here from hundreds and hundreds of questions, the essence of a number of them. What we've got is, we would appreciate good solutions for when the same data is collected for different purposes and then has different retention periods. Anybody want to jump in on that one? Any thoughts there?
Well, I think the first thing to say is it is a minefield. It's very tricky. I think this draws back to your earlier question in terms of how granular you go as an organisation. And I think you need to be clear about those different purposes and what the different retention periods are. I think the logical and sensible approach will be that if there is a latter retention period and it needs to be retained for that period, then you should stick with the longer period, because if you go with a shorter one, you're not going to have it for that purpose. And I think if you're clear about why you've done that and why you've gone about it, that should provide you with a defendable position if it's challenged. That being said, I think, you know, it's touched upon earlier what Simon was saying in terms about this very much being a burning platform. It's really important that organisations review and monitor this on a regular basis. And I think there's a broader message in that outside of retention in terms of GDPR that we've seen prior to the 25th of May 2018. We've seen a lot of talk about what you're going to do to comply up to that period rather than having a longer term strategy. And it's really important this is looked at and continually reviewed on a regular basis, and that reduces your risk element in itself, because if you let these things slide, then they become more of a risk.
Yeah. Okay.
I think also it goes back to your data categorization as well. This is where that becomes really useful, because if you've got data for more than one purpose, you should have identified that as part of that categorization. And if you've made a decision to base your retention periods on a record type rather than a purpose type, you will have something that will help guide you on your retention. Certainly, I'd agree with Matthew, where there's been conflict or contradiction, we've tended to feel that the longer period is the safer period to retain for. And again, you've got your documentation that shows your decision-making process and that will justify that retention if anyone questions it, but regular review as well.
I think I go back to my point. I agree with all of that, but I would challenge the people who are helping you retain your data to give you data minimization and kind of de-risking approaches, because you may still be able to use the data but slightly adjusted so that it's less risky, still gives you what you want. And nowadays, you know, the data architects and data scientists are really clever people. They absolutely know how to do things differently. And, you know, maybe we just don't challenge enough to get those new creative thoughts into the mix. Because I think if you sit alongside the data scientists and architects, they will come up with things that are clever and innovative from a blank page. If we can give them that blank page and say, here's what we want you to do, what can you come up with? We might find that we can still do our data retention obligations in a way that is helpful. Bearing in mind, we talked earlier about data mapping. Many people in organisations now have virtual data. They don't have it in a particular place. So even if you tried to map it, you've got a cloud environment that's constantly changing, as it should, to meet your commercial requirements. So data mapping is a lovely idea, you just can't keep hold of the data quickly enough to map it, in which case the data scientists, the database architects, all of those technical people will have capability because they're running it now. They have to run.
I think there's a real key takeaway in terms of what Nina's saying there as well, in terms of challenging your organisation, because I was thinking when you were talking earlier about this conflict in terms of asking individuals or areas of the business why they need to keep data, and I sort of sat and thought, well, it's a classic privacy challenge of the privacy officer is asking why and the business is asking why not, and it's one word but the polar opposites in terms of what the business wants. And even if you challenge when there's compliance or an argument to keep it in respect of GDPR, if you question on a regular basis, then culturally you can train the business into thinking about, well, why actually do we need to keep this? What is the benefit for us as an organisation? And hopefully you then break down the barriers. So when they come to you, they've already thought of those answers and outcomes. And
I think it's also interesting to note that the contradiction isn't necessarily between the privacy officer and the organisation. It might be in your industry standards.
Yeah.
So a really good example of where we had conflict on retention was when I worked in the NHS. And I worked for a mental health trust, which was a joint NHS and social services organisation. We had one record, which consisted of social services and mental health. However, the NHS have one guideline for records retention and the social services have another guideline for records retention. So much as a privacy officer in that situation, I could ask the why and work to look through the risks. We literally had two industry standards with different periods of time. And so it's about understanding that whole picture as well as your internal picture as well.
Yeah, I think that's a good point. I think also in the commercial world as well, just to pick an example, for example, let's imagine that you're selling a product or service. You're going to have transactional data that applies against that, which you may have a specific period of retention against. So, for example, retention of the financial data around that. But you might equally have a customer service period or a warranty period or period of to manage complaints or returns and things like that. So you might, out of one action, have other actions that are necessary. So other purposes, shall we say, that are necessary off the back of the original purpose. That are intrinsically linked, but may well have different retention periods.
I have an even more interesting kind of combination of issues where you have personal data in a blockchain activity, where if you take the personal data out of the blockchain activity, you've affected the integrity of that blockchain link. So some of those things have to be, as Claire said, kind of managed together. You can't take them out because it will then challenge the integrity of the information that you're working on. So quite important.
We've got quite a lot of other questions I wanted to turn to. We dealt with one of those up there, CVs. We've sort of touched on that, but I need to direct the approach for donors in conjunction with a question that came in direct to Claire, which was how long do you hold donor data? What consideration is given around legacies? If we can deal with that one, I then want to get back to the sales and marketing driven questions up there. Okay, Claire.
Okay, so donor records consist of a multitude of information. It's general contact information, it's financial information, it will be information about marketing, it will be where they've participated in an event. We've taken a pragmatic approach and looked at it as an entire record, so rather than different categories. So we have a donor record. And with that, we're looking at how long the donor interacts with us, when the last interaction was. And one of the questions that I tend to ask the teams if they're talking to me about retention is not just the why, but also the what would happen if you didn't have that information. So let's take this personal data out of the equation. Is your end goal affected? Can you still reach your objective? And also to we say put that donor hat on. So you are the donor, you're the person. How would you feel if you saw that we held information for 10, 15, 20 years? And what do you feel about that? As an organisation, we've tried to come up with a relatively pragmatic approach that enables us to understand the transaction history and understand our interactions with donors more broadly, and that we're trying to achieve through anonymisation at a certain point. So the donation information has to be held for 6 to 7 years because of the financial aspects and the gift aid declarations and tax information. And then from there, we will cut down the personal data based on why else it might be needed. The legacy question is a really interesting one. And for those that aren't in the charity sector, this occurs where an individual will gift us either money or property in their will. However, people can challenge wills, and therefore we're asked to evidence our relationship with the individual. Now, we can't retain every donor's record forever on the off chance that they might leave us a legacy in their will, although some people will argue that that is a reasonable position to be in. So what we do there is we try and look at statistical analysis of our information. How many people that leave us a legacy are known to us? How much information do we need to evidence that relationship? And what's roughly the length of time between last interaction with the charity and the individual's will being brought into force? And that can help you to navigate and come up with a retention period, most likely a lot longer than you would normal donor data. But again, we have various different types of legacy supporters. So if we know they've left us a legacy because they've told us, that will enable us to have a justification for holding longer than somebody who has just made an inquiry about leaving a gift in their will. So again, it's about that pragmatic approach to try and find a middle ground that's comfortable, but certainly not everything forever.
Yeah,
somewhere in the middle.
Okay, thank you. And just before we move to the next slide, there are two questions here that are sort of similar. The one is, how long is it reasonable to keep on a hold of customer data when they've either bought something or not completed a purchase, and then sales and marketing want to keep data forever just because type question. This sort of dovetails data retention into PECA issues, marketing issues, a whole range of things. I don't know, do you want to comment on either of those, Simon?
Yeah, I think the prospect one's quite an interesting one, because I think in terms of customers, I think we've probably to some degree talked a little bit about that one, but the prospect one I think is quite interesting, really. And I think there's a few bits, I guess, to think about that. As you say, PECA is relevant in here, but also whether, where did you get that prospect information from? The provenance of the data has got to be so important here.
And have you given them notice within 1 month that you've acquired the data?
Absolutely, yeah. Yes, absolutely. So it kind of is, it does kind of take in the other kind of requirements of the law. So, for example, is it first-party data? Did you collect it yourself, or did it come from another organisation? How transparent was it that you have the organisation, you have the data? Are the individuals likely to be aware that you're holding it? Because that may affect your retention period as well, I think. Which lawful basis are you using? Are you processing under consent or legitimate interests? And whether there should be a difference in the time period. I've heard it argued, actually, should it make a difference or not? But also, I think the buyer life cycle is important here, because in some situations there can be for a prospect, there can be a very long buying cycle, particularly for business products. There might be a very, very long extended life cycle where it may be appropriate to have communications over a longer period. For others, it's a very, very short life cycle. So again, depending on your sector and how that works, there can be quite different answers. So I don't think there is a stock answer, if I'm honest, around prospects. I've seen, to be fair, I've seen 24 months quoted quite a bit, and I think that's been used in other guidance. But I think it, again, like any situation that we've discussed today, you have to consider your own environment and your own trading situation and what's appropriate for you. I think it could be a short period, it could be a longer period.
Okay, and we've got a whole load of other questions come in, which I'm going to try and take before we finish. But in terms of actual implementation, and I'm sure everybody around the table would have experience here, Nina, how do you get the staff buy-in, having done all this wonderful work?
So I think that everybody's laughing around the table. Clearly there's an issue here. I think it depends on how you explain what you're doing. For many, it's, where is the benefit? What is this going to mean for me? Is this going to mean I have better access? I have more controlled access? People know what they've got, they can rely on it, they can start building inferences. So it really does start with why you've got the data in the first place. and then they themselves will work out their own answers. So we're looking at the moment on around things like, you know, which country has particular requirements to hold data in country. That then will influence how we position our data centers. It will influence what our business teams can rely on. It will impact on how we design our security by design. All of these things make data retention come alive. It sounds like a really dull thing to start off with. I don't think so, because I love privacy, but for others it's an issue. Oh God, I've got to look at data. But as soon as you start saying, well, do you really need this data? If it gives you a massive boost in commercial opportunity because you've got more data information, more analytics that you can run, and you can use indirect data, then of course people will stop thinking about data retention as being dull or tedious, and they'll be thinking, oh, I wonder if I just do that little tweak, that slight addition or the secondary data tagging, will that give me an enormous amount of insight that I can now work a new revenue stream? So to get people to help you implement, in a sense, you have to help them implement their own requirements. And that, I think, comes down to understanding, to awareness, and to any use that you can explain. And I think that goes back to where Simon started us off. What are you doing? Do you categorize? What kind of basis are you using? Because data retention then becomes not a data retention issue. It becomes, how do I use this information to drive my business commercially? Because it isn't a retention issue then, it's I've got this information, it's a commercial asset, how do I use it best?
And then there is a comment on, or what question there, which sort of is very linked to that, is if the whole point of the retention policy is to drive value through data, we know loads of regulators are saying data is a commodity, but then you also owe an obligation and a duty to the individuals out of whom you are making commercial value. So what do you do at the end? There's a question here about what do we do when the period has finished and we no longer need it. I know, Simon, you've been looking at this in terms of the guide, the end of life issues. Do you want to just make some comments on that?
Yeah, that's a good point. Okay, thanks, Robert. So the obvious thing, first of all, is you may wish to destroy the data, but you need some considerations, I guess, at that point. As I think, as Nina's talked about here, is that there can well be value in data when it's depersonalized. So you may wish to anonymize that data and retain it in a completely anonymized form, which might be valuable for management information or for analytical decisions to help other parts of the business. But that's quite often the case in my experience, that organisations would want to retain an anonymised data set for a longer period of time. So that's another option. I think the other thing is to think about that we don't only hold one version of that data. We often have a backup, on which you consider what happens with that backup, and that the backups are regularly updated. So one thing I just touch on is about whether you should consider whether that's put out of reach for your backups. There's some guidance that the ICO and also the French data protection regulator CNIL's produced around that area as well on backups, if that's which will apply to a lot of organisations. And it's also got the situation where certain data may be retained for archive, for historical, statistical use and things like that, which may be appropriate. But I think a lot of organisations will immediately look to destroy the data, which may be appropriate. But I think it is important to identify which pieces of data you should anonymise, and being specific about how you're going to use that in an anonymised situation.
Mm-hmm. Okay, thank you. Let's just move on to the final other questions, because several people, this is really around enforcement and so on, and a number of people have sent in questions saying, for example, when do you think the ICO will start to take an interest in this subject, given the challenges organisations already have? We've got this particular one, what are the likely sanctions going to be? I'm going to throw this one at Matthew as somebody that worked within the ICO. Do you think that at some point this will get on the, it'll come to the attention of the ICO if it isn't already there?
I mean, I think retention is on the regulators' radar as a real tricky area for organisations. We've not seen any sort of prevalent issues or fines purely on retention, but I think the thing to say, and I think you loosely touched on it, and Nina jumped on it quite rightly, is not having it as a get out clause of let's get rid of this information as quickly as possible. But I think it certainly called out the issue that if organisations retain data longer than they actually need to, and then that creates a subsequent risk in terms of mishandling, losing the data, etc. It can act very much, I think, as an aggravating factor in cases for enforcement where data has been mishandled or misused. But in fact, if they hadn't have had it, the data wouldn't actually have been at any risk. So I think it will continue to be a key cornerstone, and I think that's why data flows and records management, whilst not necessarily an explicit area of GDPR in itself, is a real key area in terms of overall management of data. So I think it would be interesting if enforcement was placed on retention entirely, and I'm not sure we'd necessarily see that, but I think as a factor in having real detriment on individuals, because I think retaining data longer than maybe is necessary in itself doesn't necessarily have real detriment on individuals, but if as a result of retaining it, it's then mishandled and misused, then it definitely does.
I think in the case of the German regulator, it wasn't the retention, it was the fact that there were archive systems that couldn't delete, and they said, can you please check, this is an important area of compliance. And when they went back for the next visit, they found that the company hadn't actually paid attention to that suggestion. And so what they then said was, look, we tried our hardest to, I mean, I'm paraphrasing here, that we, the regulator, tried our hardest to alert you to things that you could do differently. You didn't seem to pay any attention. And I think thinking about the fines, it's really Matthew's point. The regulators are giving us outputs, guidance, assistance, and so on. They're explaining their views with many areas. Data retention is no different. The fundamental point is there is a requirement to do certain things. We should at least take some steps to put our houses in order, because these things aren't new.
And that probably stays, the point that Nina's making probably stays back into the accountancy principle in terms of if an organisation hasn't taken ownership of an issue and properly manages it, it brings broader questions in terms of their overall governance and management from a privacy perspective.
Yes, and I think when you realise this is one piece of a big puzzle, you know, you're supposed to give plain, transparent language at the outset, including how long you may be keeping data. It needs to be fed into your record of processing, as Simon said, and it's no longer satisfactory to just have a very plain, simple policy, because that doesn't give transparent information. And I will, from the lawyer's perspective, say I am sure we will have more litigation and more investigation around this, issues arising from loss of control, because that's the sort of current phrase we're hearing in some of the courts. And if you have got data that you can't justify why you've got it and you've lost it, you can be sure, I think, that things will go from bad to worse. I wanted to finish very quickly on one question, which is, I'm not going to answer it. It's such a good question. It says, what happens when you're keeping data for two controllers? What if they don't agree on the retention period for shared data? I'm sorry that I have thrown that out on the table.
I shouldn't put Claire on the spot, but I think she alluded to this issue in terms of when you've got two data controllers. But
it depends on your relationship, doesn't it? If we're talking of joint data controllers here, then it should be specified in your arrangements at the beginning as to what your retention period is. If you're talking of two independent data controllers that have the same data set for different purposes, then you're highly likely to get two retention periods.
And I suppose you could be the host for them here.
You could. And as a data processor, maybe that's the point at which you exercise your right to tell the controllers that you think their instructions are in breach of the law.
Interesting.
And
Okay.
also that challenge around the joint controls there.
Yes.
It might be that you've got concurrence on this when you actually become joint processors, and 5 years down the line, it may be quite a different situation.
So we've reached the end of our allotted time, and I am most grateful, and I'd like you to join me in thanking Nina and Claire and Matthew and Simon. And I want to thank Nalisha, who's been handling the questions as they've been coming in. As I say, this will be recorded. It'll be available before too long. Immediately after we finish this, we're actually going into an internal meeting to look at version 9 of the draft data retention guide that we're putting together. So if anybody is interested in learning more about it, please email either myself or Simon. And I'm sure you've got the email addresses of our presenters. If you've got any individual questions, by all means, go to them. Sorry that we didn't get to all of the questions that came in. And Simon, any closing remarks from you?
Thank you. The only thing I did want to mention, just to touch on what Robert said there about the guidance, is I think you said this at the beginning, but a reminder about case studies. We are looking for more case studies or more examples. If there's any you'd like to send over to us, please do. Thank you. It's been interesting.
Thank you, and we look forward to being with you on another occasion. Thanks. Bye-bye.